Good evening, chat. Hello. Ooh, do I hear an echo? Echo, echo, echo. No, I don't. Good evening, chat. It is Tuesday night, and yeah, we're gonna talk about some judges getting spanked tonight, and not in the sexy way, but getting put down, and being put in their place. So you're gonna love to see it. You're gonna love to see it. So we are gonna get into this. About time. Hey, I started. It was 8:06 when I started, so I was only 1 minute late. Once you click fire it up, it's up. So, German on Fire says, "What's up, Sean? Not much, guys. Hope you guys are doing well. After kind of had a bad night last night, and I don't mean here streaming, just dealing with shit. Today was a better day. Today was a better day, which is good news. Hope you guys had a good day too. Hope you guys had a good day today. So, um, oh, what is Nico saying? Oh, that opening makes me wonder if there's nothing that 100 men or more could ever do. Why do you got to ruin Africa like that? Why you got to ruin Africa like that? Becky says hello. Yes, hello, guys. Yeah, and tonight we're getting back to we're kind of Karen Reed. We're getting back into some of the political stuff. I know you guys like just want to talk about different topics, but I do know you guys enjoy this legal stuff once in a while, this political stuff, and yeah, I think we'll be able to hit back up on it. We've got things coming. This week, depending on the day or depending on what we have scheduled, we might be talking about what's going on with Mahmoud Khalil and also what's going on with Kilmar Abrego Garcia. Because there's some affaring that is probably going to happen, and the district courts are trying to stop it. So it'll be interesting. The farms crashed, so I had to go outside. Yes, I had to go to work today. I was getting ready to I was ready to go in the farms this morning, and it's like, oh, and I'm like, fuck. Well, I might as well go. I might as well go do work today. So, yes, my water broke last night. No, I wish it was that simple. No, something really bad happened to a client, and feel really bad for him. Not a whole lot we can do about it, but we're able to help move on from it, and it's not their fault. So that's the good news, and it doesn't hurt their case. So, is what it is, chat. But anyways, guys, welcome to the show. If you're new, I'm Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area, and today we are going to get into this. So let's get going. We already got 161 on YouTube, 39 on Twitter. I mean, we're getting people everywhere tonight. So let's go. Sweet Bovite says, it's been a while since I tuned into your stream, Sean. It's nice to see you again. Well, thank you for being here. So, Africa ruined itself. Well, I mean, yes. And also, Chad, I forgot to mention Friday, my hair getting done. I got my hair getting done. It's going to be great. It's going to be great. My hair gets done. I'm looking forward to it. It's going to be the best. It's getting so long. It's even driving me crazy. So I need to get my hair cut. Let me see here. Why did this not go through? Hold on, chat. I need to send this out. No, not a message. That's why it's not working. All right, chat. Took care of and made sure that thing got done. What did this person just send me? Oh, yes. We are going to talk about the Karen Reed thing, guys, coming up. We're not doing that tonight, but we are going to look into that here coming up here very quickly. BobTube is a member again. Thank you, Bobbert. Did everybody ever call you Bobbert before? Because, yeah. So when I remember as a kid, one of my jobs I had, my direct boss was Bob. My foreman was Bob. Guy in charge of our department, Bob. Then the guy in charge of all the things and all the other departments was Bob. So you had Bob, you had Daddy Bob, and then you had Fire You Bob. So, but yeah, you ever get called Bobbert? And I asked him one time, like, because they were just everybody was making it as different Bob names. I'm like, anybody ever call you Bobbert? And he's like, we were eating lunch and he stopped and looked at me. He's like, if you ever call me that again, I'll fire you. And I'm like, all right. Weird AI stars in the music video of Weird All Stars in the music video Africa. Really, I didn't know that. No. Bob says, would I let Mark Randazza defend my name? Sure. Only I can afford Randazza, but yeah, he's good at what he does. Russell Greer filed a motion for new sanctions today. Ooh, buddy, that's interesting. We might wait. I don't know. Well, we might touch on that. We might touch on that on Thursday night. I'm not sure. So Toto is touring with Men at Work. Wow. Because Men at Work's the Land Down Under guys, right? So where's the Spanked vids? We're getting to it. You got to build you up. Am I getting a dye job? No. My Hitler Youth look incoming. I mean, yeah, when I get my finger length, yes, it kind of looks like a drop fade. I get it. The way they do the way my lady does the lady who cuts my hair, she does a great job at it, by the way. She gives me a finger length, but it's a finger length with like so much on the side. Yes, I look like I'm about to invade Poland with a half track. But yes, it is there. I should become Ian Uncle. I can't do my hair too long. It drives me crazy. And my hair gets all wiry and like weird once it starts growing out after a certain point. I mean, this is all like, look at my hair. Like, it's good, but like it's a mess once it gets going. So no, I can't do Runkle. Especially nowadays. So, Death Angel Shadow says, I come up after a grueling day of pounding the keyboard in my basement office, just looking at Chili and watch some tabletop related news. And you just had to love with something better. Hey, I'm trying. Sometimes I know people say that. I'm like, that's a little the ADD. And like, just focus. So you got to do it. Yes. Bob's all the way down. Yeah. All right. EDW Raptor for one sub chat. Start the night off strong. Chat. Let's fucking go. Remember, chat, when you do your part, you become a member or you gift a membership, you are effectively crushing the grays out there. You are putting in that work. Just think about it. You empower Clyde every time. The more you do that, the more you empower Clyde to crush more grays. Robo Clyde is on the prowl. And speaking of Robo Clyde, I wonder if we can get real Clyde. Hey, Clyde. Here he comes. Click, clack, click, clack. Come here, Bubberkin. Hey. Come here. Hey. Hey. Up here. You got to get up here, buddy. Come on. I'll give you something up here. Come on. Yes. It is time for Clyde, chat. We've got Clyde here. Here he is. That's right. Buddy, I got something for you. Here you go. You're such a good boy. Is that it? Is that it? All right, Clyde, let's keep going here. It's time to move. It is time to move. Oh, Maddie B says, member for 12 months. Thank you, Maddie. Thank you for being here. 12 months. Yes, you joined us on the Trump assassination show. Thanks, Sean. We never met y'all otherwise. Well, there we go. Okay. Yes, don't forget to buy your Clyde shirts, chat. You guys could buy those at the link below on Teespring. We got some Clyde shirts there for you. Yes, Clyde does a meh, meh, meh. Apparently, that's a sign they're super relaxed when they go. Did not know that. Can you give us an awoo? Oh, come on. Come on. Come on. Do the thing. Do the thing. Buddy. Come on. Hold on. He's going to do it. There, he did it, chat. He did it. What about the Meth Raccoon? Meth Raccoon is also up. Make him do a Count Dankula. No, Clyde doesn't have to. Clyde doesn't do simple gestures. Clyde is a man of action. Clyde is a man of action. What do you think, buddy? Oh, he's like 2.0, still has dinner. He's like, I go look for it. All right, buddy. I'll set you down. It's okay, Bubba. You're such a good boy. Such a good boy. Oh, Clyde has no more Red Rocket. He doesn't. So you need to teach him. Now you need to teach him to rub your belly. I wish I could. Yes, I wish I could. The Roman salutes. Well, Clyde doesn't do the Romans. Clyde does things you need to do while you're doing Romans. Anyways, chat, let's keep going here. Let's get to some stuff. And we'll start off with, and this is a very interesting comment by a guy named Steve Vladeck. He is he's an attorney. He's a law professor, does constitutional law and Supreme Court stuff at Georgetown, I believe. And he's kind of one of the more, not like I'd say the most preeminent, but he's kind of out there. He's kind of important. It's kind of a big deal. And he points out something. Since April 4th, SCOTUS has issued 15 rulings on 17 emergency applications filed by Trump. And he says the 3 birthright citizen applications were consolidated. It has granted relief to Trump in all 15 rulings. Well, this is where I'd ask that guy, what about all the preliminary injunctions that were granted? How many of those got granted? Like almost all, like a ton of them. An overridingly large percentage of them. So yes, this is maybe the Supreme Court having to. He's upset. He's upset that the Supreme Court has granted all these emergency applications for stays. And we're going to go over 2 of those stays. Does that mean he wins? Yes. But Chad, it's not like a, binding decision when it's just like an application on a stay, meaning the lower court said something, the district court did an injunction, the Court of Appeals sustained it, and now the Supreme Court's like, no, we're going to pause. But yes, it's almost interesting. It's like, why is the Supreme Court having to do this? That's the question you really should be asking, Mr. Professor Lawman, with all your professor law books. Yes, suffer, Steve. Why is it happening? Why is this thing happening? Why is it happening? Because his fucking lower court's fucking running amok. Internet State says maybe Steve Trump is right. Well, I wouldn't go that far. Trump's done a lot of shit I am not happy with in the past 3 weeks. So it's because Trump man bad. Now, what does this mean where he talks about these emergency rulings and these applications? Well, this is going to be one of them here, guys. We're going to go over real quick. And this is one. This is Linda McMahon versus New York et al. Yes, Linda McMahon. Yes, the wife of the chairman, Vincent Kennedy McMahon. Yes. Yes, that Linda McMahon. That is her. Um, that Linda McMahon. Real life kayfabe. Yes, more. We need to fire more people. More government agencies destroyed. More. You're fired. Yes. Make these employees fight in a steel cage match. Hell in a cell for GS-13s. So anyway, this is where they talk about a lot of these applications. See, this is where you get like an application for a stay. So here you go. This is presented kind of like as an emergency thing here because here's what happened. On May 22nd, the preliminary injunction was entered, and it has stayed pending the disposition through the Court of Appeals for the First Circuit. Okay, you're like, all right. So that is where we're at, where we're talking about this. Because look, these are getting granted left and right. Yes, more Janelle. But this is the thing here. We see this, and you're like, well, yeah. Now this one here, guys, shocker. You get Sotomayor and Jackson dissenting, as pretty much they always do, but also Justice Kagan. So this one was 6-3, and that's not a surprise. We're seeing a ton of those. You're like, to the victor go the spoils. And as much people hate Mitch McConnell, fucking cocaine Mitch did God's work there. Snubbing Merrick Garland. He did God's work, I will say. As much of a scumbag as Mitch McConnell is, he gets a salute. He gets an 07 for basically setting this up. Good job, Mitch McConnell. Never thought I'd say that, but you yes. So what do they talk about here? And this is an issue about, culling down and parsing down and reducing in force the Department of Education. That's what we're talking about here. That's what's happening here. They aren't really this is where so they're acting as though this is going to be the dismembering of it and the complete abolishment of it. So, because they're withholding billions of dollars in education funds, they're reducing the workforce. And the big thing here is they're reducing the workforce. And they're saying Congress only has the power to abolish the department. Okay, well, yeah, that's true. But guess what? He could say, in the meantime, I'm letting everybody go. So they're sitting there, and they said that consistent with the executive orders that Trump did, Linda McMahon gutted the department's workforce. Oh, God, I can't do it like this. We got to have the highlighter mode on. Linda McMahon gutted the workforce, firing over 50% of its staff overnight. Based. Monster. Kill. In her own words, that mass termination served as the first step on the road to a total shutdown. And they say when the executive publicly announces intent to break the law, it is the judiciary's duty to check the lawlessness. Well, what if there is no lawlessness? I mean, I'm not going to indulge these tards for 17 pages. But we've already talked about this. He's within his power to do that. I'm keeping the Department of Education in place. I'm just firing everybody who works there. There's nothing wrong with that. I don't see the problem with that. He's not abolishing it. He's just firing everybody who works there. It exists. It's still there. It's a skin suit. So, but yes, Bing chilling. That's what Trump is doing right there. Yes. Big riff action. Yep. The biggest riffs, chat. The biggest. So, once she wins, she should drive the DOE with their son, Shane. Yeah. No chance in hell. Oh, that'd be great. Yes. Do you think Linda ever dutied on Vince? No, but do you think Vince ever dutied on Linda? I doubt it. Did you see the response to the ACLU's birthright class? The Supreme Court's or whose? I'm not sure you're talking about. So, but that's where we're getting these things, and they're complaining about it. And then we get to one that actually, this one happened, chat. If you were not paying attention, happened on Monday. You're like, okay, cool. Going back to last week, this one here, oh man, this one here. I talked. You guys remember we talked with Ryan Mullally last week about how retarded Ketanji Brown Jackson is. Well, we've got one, chat. This is a big retard finder here. So it's Trump versus the American Federation of Government Employees. Okay. This one here is another one of the cases regarding general workforce reductions in the federal government. And this is an application presented for stay to Justice Kagan. Now, why do we have to do it through Justice Kagan? Because it's for the Ninth Circuit. But initially, the Northern District of California issued an injunction. So right now, it's stayed. Okay? That's where we are with this. And it's stayed right now. And this covers the executive order regarding the Office of Management and Budget, OMB, and the Office of Personnel Management, OPM, claiming that it's unlawful. And they say because the government is likely to succeed on its argument that the order and memorandum are lawful. And notice normally when we get the stay, we just get this much, right? This is now a further discussion of it. And they say because the other factors bearing on the grant of stay are satisfied, we grant the application. We express no view on the legality of any agency RIF or reorganization plan. Guys, remember, RIF is a reduction in force. Produced or approved pursuant to the executive order and memorandum. Okay. The district court further enjoined implementation of or approval of the plans based on its view about the illegality of the executive order, not on any assessment of the plans themselves. Those plans are not before this court. Now, notice here's what happened. So we've got that. Okay. We have Sotomayor concurring in the grant of the stay. You're like, what? But here we go. Notice what she's saying here. I agree with Justice Jackson that the president cannot restructure federal agencies in a manner inconsistent with congressional mandates. I would agree. If there's a congressional mandate, you can't restructure it in a way differently. But letting everybody go, I think, is acceptable. Here, though, however, the relevant executive order directs agencies to plan reorganizations and reductions in force, consistent with applicable law. So the plans themselves are not before this court at this stage, and thus we have no occasion to consider whether they can and will be carried out consistent with the constraints of law. I joined the court stay because it leaves the district court free to consider those questions in the first instance. And notice that Trump's executive order says reorganize consistent with your applicable laws and your enabling statutes. But notice what Sotomayor is saying, like, you're not doing this right. You're not doing this right. Uh-oh. Well, now who do we have? Justice Jackson dissenting from the grant of the application. Okay, wait. So it's just Jackson, right? Yeah, it is. So we've got Sotomayor going along with the group. What do we have, chat? What's the total? 8 to the loneliest number. That's right, chat. 1. It's the loneliest number that you ever knew. Oh, no. Oh, no, chat. They just iced the black woman out. Everybody's turning on her. Even the Latina chick is like, no, I ain't helping you out. Yeah, 8 to DEI. Yes. Because she don't understand. Oh, I know she don't understand. Yes, even Sotomayor is like, bitch, you lost your mind. Yeah, Sonia Sotomayor is like, are you wearing your bravery jacket today? Ketanji. Now she goes on, chat, for 15 fucking pages. And all Trump is doing so far, all Trump did in this one was saying, hey guys, put together plans. Not enact them, not do anything about them, just draw up a plan and make sure the law that applies to you is followed. And what did all these people do? They fucking read and scream, no, you can't do that. Read. It's like, what? Wow. What the fuck is going on here, chat? What is going on here in America today? I just don't get it. I don't get it. I just don't. I do not get it. Oh. Oh. Okay. So it's just, you're like, what the hell? What is wrong with this woman? I think she's lost her fucking mind. I think she's lost her fucking mind. Real quick, guys, Dolly Talk gifted 1 sub. Thank you, Dolly. Guys, Dolly, friend of the show. Make sure you tell him hello over on his channel. Watching like courtroom roulette. It's like chat roulette, except there's no masturbating in it. So that's the good news. That's good news. Unless you super chat Dolly $50, and then he'll start cranking on it. The Pie Baker for $5 says, "Dear Santa, I've been good boy. I want a -10. I want an A10, a dragon, a concrete plated bulldozer, Nick R. Powder, and a cat girl harem." Well, no, you don't get cat girls because they might turn into cat boys. So no. Bad chat, bad. So like I should have a rolled up newspaper. I could just like thwack. No, you don't get one of those. EDW Raptor with another sub. And then Shredder S07 gifting 5 subs, chat. I mean, really, you know what? That's right, chat. You get yourself an awoo for that. You get yourself an awoo for that. There you go, guys. There you go.
Was this story based? Yes.
Very based. Very based, guys. Big support. Thank you so much tonight. I appreciate it. I appreciate very much. And the EDW Raptor with 5 more subs. Damn. You guys are all... You guys are all about it. So, yeah, you know... all right, you know, you guys get it. Oh, chat. All right. So, Jablo Dunn says a cat boy would suffice. You're like, no, chat, no, stop it. Elda Gusto says cat girls don't naturally turn into boys, Sean. I'm not saying that's going to happen. Most cat girls are just femboys. So you got to stay away from all the cat people, period. Stay away from all of them. It's too dangerous. There's too much risk. You get a whole bunch of them at once, and then you find a couple of cat boys in the middle of it, and now you're stuck with them. So stay away from them. It's never a good idea, chat. Never a good idea. Yes, LCW is correct. Cat girls don't exist. Only cat boys dressed as cat girls. Yeah, that's why you got to be careful. You got to be careful. Tech Guy says Freebird. We need some. Freebird requires a little bit of something else. But yes, we're making our way downtown. Yes, if you want Freebird can happen, but you got to earn some Freebird. Only Fox girls allowed, yes. Bredicus says deport all furries. I mean, that's hard not to agree. That's hard not to agree. Eric Duff says the Graper Army assemble. Well, half the Graper Army's cat boys anyway, so that's not really a threat. Yes. When does Tierno Fuentes stream? When did it not? When did it not? Cecilia said, dang, look at all this. Yes. And then Jim, how you doing? How you doing? Based Foxu girl, yes. Well, that's like I said, that's different. That is different. All right, chat. Well, anyways, keeping with the trend of things for the birthday, because we're coming up to it. 2.0 has another thing wrapped for me to do. And she kind of looked at me today. She's like, there's too much shit to wrap. I'm like, well, if they come in, like, are you ordering it off Amazon? She's like, yeah. I'm like, well, there you go. It's already wrapped. So we'll try this. Jesus Christ. Ooh. Ooh, wow. Does this come with the people on it too? Or no? Wow. Well, chat, I don't think wow. This is neat. From the lovely future Miss Amara 2.0. It's Katie, it's too much money. I mean, it is. It is too much money. I do feel bad about this. I feel bad when people get me shit. It's a Switch 2. It's a Switch 2. Oh, fucking. Sweetheart, you never got me a Switch 2, right? Good. Because, like, immediately I'd be like, paint the wall of my skull. Oh, this is cool. This is going to be neat. We might have something to do tonight, chat, because we're on to the big story for tonight. But, pow! 135th scale motorcycle. Like, we can have some fun with this. Building shit tonight. This is something we could do. So, hell yeah. Thank you, sweetheart. I very much mean this. Thank you, mon chéri. I do like the warning on here, though. Like, you know, this could suffocate babies. I'm like, what kind of baby could fit his fucking head in this bag here? But, that's not a Zaku. No, they look vaguely German. Yes. Katie said, I'm still waiting for video game night. I know. And I got to, well, one of the biggest things I got to do is I got to buy, well, I need to buy it. I got to get an SSD. I need another, kind of running out of fucking room, even on my D drive. And I need to like get like a 4 terabyte SSD and just like shove everything on there as much as possible. So I have way too much shit. I ain't going to be rolling down Rainbow Road anytime soon. No. Is that like the Barbie scale? No. What scale is Barbie? Hold on. That's actually a good question. What scale are Barbie dolls? What scale are they? They're 1/6 scale. That's kind of what I thought. And 1/6 is very big in scale modeling. That's where you do like you buy like a soul figure and you put them together and paint them. Yeah, so 1/6. That is correct. Summonable trap. So, is it? What the hell is Rainbow Road? I think they're talking about Mario Kart. So, I don't know. I think it's one of those racetracks Darkside Phil keeps driving off the side of. So, delete all that anime porn. You first. You first. Say, Felzu says, I have a Zaku. So do I. So do I. So do I. It was hide behind the Clyde treats. Hiding behind the Clyde treats. So there you go. 3 1TB SSDs will do you fine. I don't know if I have that many data or SATA ports on my motherboard. I think I have 2 when I looked before. So there's a 3/5 scale. Oh God. Yeah. SSD is fine for storage. What's going to be for storage and like other apps and things? I'm going to see what I can shove on there. Not just storage, but like what installed programs and things I can put on there, because I need to save the good drive for like games and stuff. So, but yeah, we might have something to do tonight. Yeah, two, yes. Gina says, "Don't ignore me." What did I ignore you? What did you say? I don't see. Did you say something? I don't see it. Where did I ignore you? Oh. Let's see here. Oh, real quick. EDW Raptor with 10 more subs, chat. He's trying to freebird this himself. He's going to be a one-man freebird here, chat. I mean, I don't know what to tell you. He's going to do it. He's going to do it. Miko says, what the hell does it do with the Supreme Court? Everything. And nothing. Yes, I heard about the Karen Reed juror. We will probably address that on Thursday night because there's a lot to go through there. Stabby, I'm going to get fine. You know what, Stabby? I'm going to give you a whole list of shit to print tonight. How about that? You're gonna get so much shit to print you won't know what to do. Play the clip of PPP standing up for money. All right, guys. Now moving on from there, we are moving on to the case of Hannah Dugan, the judge in Milwaukee. If you guys remember, she's the judge who, when ICE came by looking for a guy to arrest, and they had an administrative warrant, which is all you need to arrest somebody on immigration issues. You don't have to have anything special. You know, if you've heard people say, like, you need a judicial warrant. There's no judicial warrant. It's an administrative warrant. So that's how it works. That's how it works. Like, that's what you need. That's what you get. You get an administrative warrant. Like, there's nothing, like that. That's it. That's it. Anyway, so they were there and I'm going to try to bring this up, the video. So if you guys did not see this before, here is the video of what happened. This is the video of her. I mean, look at her. Sherry looks like a pleasant woman. So here's the video of her coming out, and she's already coming up. These guys are the ICE agents. This is her and another judge. She tells them, you guys need to fuck off and go down the hallway to go see another judge, the presiding judge, the administrative judge, the judge in charge of the courthouse. She's like, you can't sit here. And these guys, being good law enforcement officers, look, we're not going to piss you off. Fine, we'll go see him. So she goes and does that. She herds them away. They end up getting herded away. She basically shoos them on, shoos them out of the way. And as she does that, hold on here, chat. Sorry. As she shoos them away, sorry, I skipped ahead too far here. As she shoos them away, coming out of that hallway you saw down that way is this guy here. And he's an illegal. And right here is another ICE guy who was sitting there who didn't get his cover blown. So remember, this judge let him sneak out the jury doors instead of the main courtroom doors. And as you can see, they snuck out from down here, and they snuck out and went, woo, and they ran. As this happens, they get out the door, and this guy's like, oh, shit, it's them. I better follow. So they go leave the door, and he runs out. Oh, shit. Shit. All right, chat. Sorry. Damn it. I was doing so good. Actually, here we go. This is actually better footage. So here's the footage. Here are the ICE guys fighting for the blue team. Actually, these guys are fighting for the red team. A bunch of federal agents in plain clothes. You're like, no shit. No shit. So they come and sit down and wait. Now, down this way, they're all waiting. And they go down into her courtroom. Down here. This is the judge's courtroom. And they're going to try to find her. They're going to try to find her. And they're like, look, we have a warrant for this guy. I'm sorry, wrong side of the room. Wrong side of the hallway. This is her courtroom down here. They come walk down. They're coming to have a seat. As they sit down and wait, they wait. We're looking for the guy. At 8:38, this is the guy they're looking for, Eduardo Flores Ruiz. And they beat him there. And he shows up to court. Now, from here, this is the room to the jury door. Okay. So this is how, like, during, if there is jurors involved in something, they would come in and out of this door in the hallway. So the judge uses this door. Now, once again, they're still looking for this guy. You're like, okay. And this is after the judge has already shooed them away. She's already kicked them out and said they need to leave. Said they need their warrants. So this is the guy they're looking for. And this is the judge and another judge, Severa. They both come out in the hallway acting like hoes. They're angry hoes, and they come out and they come out and say, you gotta go away. This isn't your plan. She kicks all the agents out of the hallway. I like how this guy was hiding far enough down the hallway, nobody fucking noticed. So he sits there, and he's hanging out, and he's like, well, fuck me. So he comes back out into the hallway after he's done. And this is where, once again, you can see Judge Hannah Dugan, that's her courtroom. And she comes down here, and later on, this is when she tells the illegal, hey, sneak out the other doorway. Because remember, she thinks they're all in the office. So they're going to sneak out. Him and his attorney, and I don't blame the attorney for doing this. The attorney's doing the attorney thing. And no, that's not me, chat, walking by. So as it happens, the agent's like, wait, I know that guy. It's like, no, wait. So I like how she's just like sitting. It's like wearing your Yankees stuff. Like, did they go to Goodwill to buy those clothes? Like everybody else is wearing like stuff. She's like, I'm wearing my Yankees starter jacket. It's like, hello, 1994. So she's catching up. And then the other guys come out very quickly afterwards. And notice, Eduardo Flores Ruiz did not take this elevator. He kept going down the hallway. They took a different elevator to avoid detection. So they're going to look for this guy to catch him. They're going to look for him to catch him. They keep going. They keep going. And they're like, ay, ay, ay. Oh, no. Vámonos. They're trying to run away. Help us. No. And he gets caught. He gets chased along. She starts waving along. Guys, come on. We got him. And here he is leaving with his attorney, his public defender, and they leave. She walks him out the door. And here he is. They approach him and he runs away in front of traffic like a retard. You know, why run? You're only going to get tired. Like, they know where you're going. So they catch him and they arrest him. And, you know, as he does, he admits he was here illegally and has been convicted of being here illegally. So, yes, he gets a flared. He gets a flared. And yes, P-Dub is right. Hose mad. Hose mad. Hose mad. Although it's times 24, not 10, I believe. So, Garrett Pace says, get fucked, Judge. The hall ain't your courtroom. Even if it was your courtroom, there are limits to your authority as a judge, as we're going to find out here. What's with the creepy red tracking boxes? That's just the software. What state was this? Wisconsin. Milwaukee, Wisconsin, chat. So where is he now? He's in federal custody getting a flared. And remember, Judge Dugan was charged with a couple of federal crimes. Well, she tried to file a motion to dismiss claiming judicial immunity and arguing the Trump v. United States protected her. So remember, in Trump v. United States, they said there's 3 classes of action. Action that's completely not protected, action that's fully protected, then there's that stuff in the middle. Well, I think as Robert Gavay says, like the 3 buckets. Well, here's what you see. On May 13th, a grand jury sitting in the Eastern District of Wisconsin returned a 2-count indictment against Milwaukee County Circuit Court Judge Hannah Dugan. She's charged with 1 count with knowingly concealing a person for whose arrest a warrant and process have been issued. As she's charged with obstructing the United States Department of Homeland Security's removal proceedings. And this is a magistrate's finding, chat, just so you're aware. But this is a report and recommendation. So a magistrate is writing this report and recommendation to the judge because the judge looked at this crap and was like, I ain't dealing with this. Magistrate, you handle it. And when you're the magistrate, you do the judge's bitch work, including all the crap the judge does not want to do. All the crap the judge does not want to do. So this is the United States District Court of Eastern Wisconsin. It's a report and recommendation for the magistrate. So what happened? So she moved to dismiss the indictment on the grounds she is immune from civil prosecution because of judicial immunity. And that her prosecution violates the limits of powers under the 10th Amendment. And the indictment could be dismissed under the canon of constitutional avoidance. So she's arguing she has judicial immunity as well. They say, for the reasons below, I recommend the motions to dismiss be denied. So they talk about the count 1, and they basically break down the 2 counts that she did here. And what did she do as far as disrupting them? Well, she did affirmative acts. She confronted them and falsely told them they needed a judicial warrant to effectuate an arrest. So she lied about what they needed. And upon learning they had an administrative warrant, she directed all of them to leave the hallway and go to the chief judge's office. So she basically said, like, no, go over here. And she addressed the case off the record while the task force members were in her office. That part, that's not that, these really, I would argue, these 2 are the affirmative acts right here. These are the big affirmative acts because she can do shit off the record as a judge. This one here, though, this is an affirmative act that's not going to work. Directing them to leave through the non-public jury door. Advising them they could appear by Zoom. Once again, I think she has every right to do that. So this is not helpful to the government. This is not helpful to the government. So she's 3 for 5. The government's 3 for 5 on things they can get away with. Yes, chat, yuck it up. Yep, yuck it up. But telling them they can appear by Zoom is not actually a problem, in my opinion. So legal standard, and here's what it is. You can raise any defense objection if a court can determine without a trial on the merits. You can raise it as a pretrial motion. When deciding a motion to dismiss, the court assumes the indictment's allegations are true and must view all the facts favorable to the government. So it's just like summary judgment. You view the facts most favorable to the light of the non-moving party. Okay. And they say the federal rules of civil criminal procedure don't provide a mechanism analogous to the motion for summary judgment in the civil procedure rules. And they say, thus, if the defense raises a factual dispute that is inextricably intertwined with the potential culpability, a judge cannot resolve that dispute on a 12B motion. Now, what does that mean? Well, all this means is you can only issue and argue about matters of law. You can really only talk about matters of law. All right? If you happen to argue a factual matter, so she could say, I didn't do it. I did this. This happened. Boom. If you're arguing about the factual merits of a case, courts cannot do a motion to dismiss. When you're doing a motion to dismiss, it's basically on the law because you're agreeing all the facts are correct. If the facts are not correct and you're arguing with the facts, we do have a resolution vehicle for that. That's called a trial. So you have to have your trial to discuss the facts. When you want to do a factual issue, you're trying the facts. Well, we do that at a trial. So that's why you don't get to do that. That's why you don't get to do this. Yeah, how are you guys making fake letters over there? What the hell are you guys doing? Death Angel says, do they have Zoom in South Sudan? Softball. I don't know how you say suffer in Sudanese, so that would be even funnier. Oh, but anyways, this is the big deal. It's just if you guys didn't realize that that's how you do a motion to dismiss in a criminal case. If you end up, and I've had this happen before, sometimes your factual issues are intertwined in there, and the judge is like, I can't do anything about it. He's like, we'll have to settle us a trial. And I'm like, all right, well, there you go. So they talk about the three indict or dismissal grounds. First, that she's in her official duties and judicial immunity applies. Second, there's a 10th Amendment claim. And third, there's constitutional avoidance. Now, here we go. It's judicial immunity is where they start. And they say, because everybody disagrees on the law, the magistrate is saying it's instructive to begin with a survey of the law, meaning just like a brief overview and background of the law on judicial immunity before turning to those statements. And judicial immunity is long recognized, going back over 400 years to English common law. Of course, judges aren't going to let you sue them. Insulating the judiciary from civil liability. They say prior to the creation of the right to appeal, a litigant would seek nullification and a fine against the judge who rendered it. However, once an appeal system was put in place, the concept of judicial immunity arose and was gradually accepted under common law. Yes. When they talk about in the early years, there's a seminal case, Floyd v. Barker, and was decided by Lord Coke, 1607. Guys, this is we're seriously going back all the way. And it addressed the question of whether, and guys, I will say some of the stuff out of common law is actually really cool, these old cases. A judge presiding a murder trial could be prosecuted in another court for criminal conspiracy. And they concluded judges were immune, stating a judge for anything done by him as a judge, by the authority which the king hath committed to him, and is sitting in the seat of the king concerning his justice, shall not be drawn into question before any other judge. In other words, there was a absolute immunity for all judicial acts. So they point out that there are purposes for judicial immunity. It ensures the finality of a judgment. We kind of want finality. It protects judicial independence. We don't want judges being scared of being sued. It avoids criminal attacks on judges who may be sincere in their conduct. Yes. And it protects the system of justice from falling into disrepute. Yeah, don't worry. I love that because wait, judges already did it on their own. Judges already did that on their own. So, yeah. No, chat, not that kind of Coke. No. No. And I talked about the first major application was in 1868 in Randall versus Brigham. In Randall, an attorney was accused of obtaining agreement from a client that was unconscionable, extortionate, and therefore grossly unprofessional. It was removed from his office. In response, he has sued the judge for unlawful removal. And they said it's a general principle that all judicial officers, they are not liable for civil action for any judicial act done in their jurisdiction. They say, though, they point out the Supreme Court says, however, where the acts in excess of jurisdiction are done maliciously or corruptly, you can sue. They did point out, though, 3 years later, it does cover malicious or corrupt acts. They talk about in Bradley, their judge was a member of the Supreme Court was a member of the bar of the Supreme Court of the District of Columbia, and Judge Fisher was one of the justices in the court. And he said, while representing a party, Bradley accosted the judge in a rude and insulting manner. And after the judge disbarred Bradley sued the judge. They point out that the exemption of judges from civil liability cannot be affected by the motives with which their acts were performed. They say, thus, even though Bradley accused the judge of wantonly, corruptly, arbitrarily, and oppressively attempting to remove him, they concluded the judges were not liable in civil actions for their acts, even when the acts were taken in excess of their jurisdiction. So even back then, all the way up through the 1800s, it was complete immunity. The most complete immunity out there. They talk about in the modern era, they move on to Pearson v. Ray. And this is an actual case you get to deal with because, notice, it's under 14 USC 1983. So it's a deprivation of rights under the color of law. And was this local judge liable for damages for an unconstitutional conviction? And guys, remember, 1983 allows you to sue state actors for depriving of your rights secured by the Constitution. And they say the plaintiffs were members of a group of white and African-American Episcopal clergymen who attempted to use segregated facilities at an interstate bus terminal. Remember, this is back in the South, and they still had segregated facilities. You know, drinking fountains, bathrooms, benches. They sued local cops and a local judge for false imprisonment. And they say the court had no difficulty finding the judge was immune for damages in his role of the convictions, as few doctrines were more solidly established than the immunity of judges. The court, and this is 1967, it applies even when the judge is accused of acting maliciously and corruptly. It is not for the protection or benefit of a malicious or corrupt judge, but it is, but for the benefit of the public, whose interest it is the judges should be at liberty to exercise their functions with independence and without fear of consequences. Well, then why can't we hang the judge who's corrupt? Because that's kind of the alternative, is hanging the corrupt judge. Because that's kind of what should happen there. And they say over a decade later, they did Stump v. Sparkman, and Stump, the mother of a 15-year-old girl, presented a document entitled Petition to have Tubal Litigation Performed on Minor and Indemnity Agreement. And it was presented to the judge for signature. The judge approved the petition despite the fact that it was not given a docket number, was not placed on file in the clerk's office, and was approved at an ex parte proceeding without notice to the minor, without a hearing, and without the approval of a guardian ad litem. And basically what that mean? Well, she was sterilized without her knowledge under the pretext of having an appendectomy. And once she learned about it later, she sued people, including the judge and her mother. Well, still, he was immune from civil liability. And they say that the necessary inquiry is whether at the time the judge took the challenge action, he had jurisdiction over the subject matter before him. And they say a judge won't be deprived of immunity because the action he took was an error. If it was an error, it was done maliciously, or as an excess of his authority, Rather, he will be subject. Now, here's how we find out there's a rule. He will be subject to liability only when he has acted in clear absence of all jurisdiction. So finally, we know now there is a standard. What is the standard? When you act in the clear absence of all jurisdiction. And they say because the court found that because the court over which Judge Stump presided was one over general jurisdiction, neither the errors he committed nor the lack of a statute authorizing his approval made him liable, nor to the informality of the proceedings. And they say rather the factors in determining whether an act is judicial relate to the nature of the act itself and the expectations of the parties, whether it is a function normally performed by a judge, and whether the parties dealt with the judge in their capacity. So notice we got another set of things to look at, another set of gauges to measure this by. And they said in this case, because Judge Stump performed the act performed only by judges and did so, he was immune. And notice there were a bunch of judges getting sued. A bunch of this crap made it all the way to Supreme Court. They had 2 years later, Dennis versus Sparks. They say Dennis, a state court judge, enjoined the production of minerals from certain oil leases owned by the plaintiffs. And the appellate court dissolved the injunction as having been illegally issued. So the plaintiffs, they're like, hey, it was wrongfully issued. So what do? They sued for monetary damages, saying, hey, judge, you fucked us over out of money. And Maddie, you're saying, how do you do that to a girl saying she needed to have her appendix removed? Man, the way they used to handle medical stuff back in the day, dude, was just absolutely brutal. And God forbid you were a woman on a Indian reservation and you needed to go see a doctor for anything regarding your reproductive organs. You were probably going to lose them. So, but yeah, that happened a lot back in the day. Women would get sterilized. And if you lived on the res up until, the 90s, women were getting illegally sterilized by doctors. You show up for an exam and you end up getting a hysterectomy. So, but yeah, even in the late 1900s, medical consent didn't really exist. Remember, Stump was 1978. So now what happened here? Well, in this case, they claimed there was a conspiracy between the judge and the defendants. Okay, well, what happened? Well, the judge was still immune, whether or not there was a conspiracy, and the Supreme Court affirmed. And they said that judges defending against 1983 actions enjoy absolute immunity from damages liability for acts performed in their judicial capacities. That's what happens there. So that was important. And yes, too. We'll get to that in a second. Always think of the poor Kennedy daughter. Yeah. Rosemary Kennedy, JFK's sister, Ted Kennedy's sister. She was considered to be a loose woman. It was going out and partying. She was a party girl. So they wanted to give her lobotomy. And at the time, they thought it would chill you out. Well, in reality, it turned her into a vegetable. So yes, there's all kinds of nasty, they did lobotomies on people all the time. One Flew Over the Cuckoo's Nest is a great example. But no, medical sterilization was a very common thing. Guys, the case Buck v. Bell was about that. Skinner versus Oklahoma was about the sterilization of guys convicted of felonies. It happens. So they cite another case, Forrester versus White. They say under Illinois law, circuit judges have the authority to hire probation officers, which is true, who are removable at their discretion, which is true as well. And they say, well, later on, this Judge White hired Cynthia Forrester and then terminated her employment, which he claimed was based on sex discrimination. They say a jury granted an award in that favor, and the judge moved for a new trial, which is granted, and then moved for summary judgment on the ground he was entitled to judicial immunity. And they say both the district court and the court of appeals agreed that he was immune. But the Supreme Court reversed, and they said, running through our cases with fair consistency, it's a functional approach to immunity questions. And they say, well, what are we doing here? And they say that you have to examine the functions with which the class or officials have been lawfully entrusted. So the Supreme Court said, here's the problem. You have to draw the line between truly judicial acts for which immunity is appropriate and acts that have simply happened to have been done by somebody who's a judge. And there we go, chat. That's the rub. That's the rub here. You know, are you acting in judicial immunity, or are you just a judge who's acting? So they say immunity is justified and defined by the functions it protects or serves, not by the person who attaches. They also noted the court has never undertaken or articulated a precise and general definition of the class of acts entitled to immunity. And they say the court found these cases suggest an intelligible distinction between judicial acts and the administrative, legislative, or executive functions that judges may on occasion have to perform. So they'll perform judicial acts. Those are protected, but not the administrative, legislative, or executive functions. And firing that woman and hiring her is not his job as a judge. He's an employer, and he discriminated against her. So that is why he's held liable. So the Supreme Court's found things, and it says it doesn't apply to acts like promulgating a code of conduct for attorneys. And they say in this case, Judge White was acting in an administrative capacity when he demoted and discharged Forrester. And they say, while it might be important to make a sound judicial system, these were not judicial or adjudicative decisions. The court stated that absolute immunity is a strong medicine justified only when the danger of deflected from the official performance and effective performance of their duties is great. And they point out that in this case, they were just employment decisions brought within the court's jurisdiction. They don't become judicial acts. He's just hiring and firing people. He's allowed to. They do another case here, Mireles versus Waco. And they determine whether conduct was judicial. And this is involving a public defender who was scheduled to appear before the judge. After counsel failed to appear, the judge ordered law enforcement to forcibly with excessive force seize and bring the attorney to the courtroom. And this is after they failed to appear. The court stated that the law makes clear immunities overcome in only two sets of circumstances. Action that's not taken in judicial capacity and actions taken in complete absence of all jurisdiction. They say, as of the first circumstance, the court clarified that the relevant inquiry must be the nature of the function of the act rather than the act itself. So they say, in this case, the judge ordering officers to bring a person in the courtroom is a function normally performed by a judge. Judges do that. They do it all the time. Judges issue warrants. They enforce orders. That's entirely within their purview. But ordering a judge to carry out an order with excessive force is not. You can't tell the judge, you can't tell people to go beat the shit out of them. Doesn't work that way. And they point out that you have to, it can't scrutinize this act in question because any mistake would become non-judicial as no improper act is normally performed by a judge. So they point out that judicial immunity is immunity from suit, not just from damages. And you can't be overcome by bad faith or malice. Now they point out the second circumstance. They said if the judge authorized and ratified the use of excessive force, he acted in excess of his authority. But they said it can't not be said to have been taken in the absence of jurisdiction, meaning he had the jurisdiction to tell the cops to grab him. So this still counts. So yes, chat, you're like, wait, so judges can pretty much do everything? Yes. Judicial immunity is pretty fucking much absolute. So, and they talk about, what's the big thing here, chat? What do you see in all these cases, though? They're civil. These are all civil lawsuits. These are all civil cases, chat, which is the big thing here. This is all civil. Not criminal. There's a big difference here that we're looking at. But they say that judges enjoy absolute immunity from civil lawsuits for monetary damages when engaging in judicial acts. And they say, this is not, however, a civil lawsuit. She's been charged criminally under federal law. And the question is whether the established principles regarding immunity in civil lawsuits apply here. And it says judicial immunity for criminal prosecution. Well, we have to see what happens, though. And they point out that, yeah, it, Now, what you can do if you're Judge Dugan, you look to Lord Coke's pronouncement saying you are completely immune in all ways at all times because you are a judge. And that's what Lord Coke did. But you don't get that here. And they point out that in the 154 years since Bradley was decided, Dugan does not cite, and I have not found cases where the Supreme Court invoked Floyd for the proposition that judicial immunity bars the criminal prosecution of judges for judicial acts. And they talk about most they have gleaned about judicial immunity is from 18 U.S.C. 242, the deprivation of rights on the color of law. And they say, which is not charged in this case. And they say Section 242, the criminal analog to 42 S.C. 1983, and these two work together, guys, allows for criminal prosecution for the deprivation of constitutional rights while acting under the color of law, and you can be prosecuted for that. That's what Derek Chauvin got convicted of too. It's what lies cops get convicted of. Especially if they beat the murder at the lower level or at the state level. They're like, well, they get charged with violating rights. And they keep going here, and they say that the statutes itself don't address the applicability to judges. But it applies to state actors, which includes judges. So they keep on going through, and they keep on talking about Section 2 of the Civil Rights Act. They're talking about 1866. You're seeing President Andrew Johnson talking about the case. So they talk about the problems here, and they say, the Supreme Court upheld a judge's prosecution for a constitutional violation in Ex parte Virginia. In that case, the state court judge was criminally charged for excluding black jurors from jury selection in violation of the 13th and 14th Amendments. And the judge argued Congress couldn't punish a state actor for his official acts by selecting a jury. He was performing an act, and the court disagreed, stating that the duty of selecting jurors is ministerial. And they said, however, even if it was judicial, the judge had no authority to select jurors in violation of the Constitution. And once again, we get to that idea of you can't break the law as a judge just because you're the judge. So they point out that while addressing this judicial immunity context, the court threatened prosecution under 242 to deal with corrupt judges. And they point out that judicial immunity does not immunize criminal conduct. And they say that judges, even clothed with civil immunity for centuries, could be punished criminally for willful deprivations. And it's true. Judicial immunity was not designed to insulate the judiciary from all aspects of public accountability. It's very true. Now they talk about this. Floyd gives the judges criminal prosecution, immunity for criminal prosecution, but it's an English case. It's not an American case. And the Supreme Court has only cited it for civil cases and civil damages. And they say the judges are not immune from criminal prosecution under the statute. So it's almost absolute because most judges act within their power. Very rarely do judges do it in a way where anybody could do anything about it. And they talk about her arguments here. And they talk about her arguments of absolute immunity. So, and she says there's only 3 exceptions, none of them which apply. She argues judges can be prosecuted for wholly unofficial acts. Second, she argues a judge can be prosecuted for criminal deprivation of a constitutional right. And third, she can be argued a judge can be prosecuted if she conducts an official act, but the act is coupled with an ordinary crime. So she's deciding I'm only immune in certain ways. Once again, they point out that this immunity is in civil cases. Civil. And this is the magistrate saying, as discussed above, the only time Supreme Court decided to Floyd has been in support of judicial immunity in civil cases. And the magistrate is saying, I am not persuaded, therefore, that Floyd has taken root in American common law to shield judges from all prosecution, which is what they want. And they say, due to several more recent cases that were cited, the court cited the general proposition that since the common law judges are exempt from a civil suit, or any act omitted to be done by him as a sitting judge, that doesn't mean they can't be charged. That doesn't mean they can't be charged. They say, but then again, these are not criminal cases. And the court's invocation of immunity for both civil suit and indictment provides weak support for the existence of a well-established principle. So this is how you do that. Coke Frey says he mean English common law. Yes. Well, remember, there's common law that it's law that's not codified. So we have the United States Code, but there's also case law, and that's common law. But yes, when they talk about Lord Coke in 1607, they're talking about that kind of common law, yes, English, traditional English law. Oh, hold on one second, chat. So she cites a bunch more cases, though, and they're not involving constitutional rights. And they say these cases are similarly unconvincing. And they address whether a judge is immune from conducting misfeasance in office. And the court concluded that misfeasance of a judicial officer acting in his capacity did not constitute a criminal offense under common law. And they say malfeasance or misfeasance precludes criminal liability unless the malfeasance or misfeasance is accompanied by bad faith. Because remember, if it's just a judge misfeasance, well, misfeasance is a mistake. And we don't want judges being prosecuted for making mistakes. That's not good. We don't want that kind of a law. I mean, in general, we don't want misfeasance for any type of law. We want malfeasance. And remember, chat, mal means bad. God, I forget where that meme is from. But somebody's like, well, what does mal mean? And somebody's like, mal means bad. And the guy's like, oh. I forget what it's from where that happens. So. But here's the problem. She's charged with a federal criminal statute that isn't related to misfeasance or malfeasance. Thus, it's not appropriate. She cites another case from 1944 and where the judge got indicted for depriving civil rights. And the court concluded the judge was criminally immune because he was acting in the scope of his duties. And they say that they point out that Ex parte Virginia shows the judge performing a ministerial rather than judicial act in selecting jurors. I would argue that's still a judicial act, though. Oh, that's a Simpsons. Mal means mal. Okay. Okay, I was kind of curious. It's Latin, Sean. I know that, but there's like a, yeah, like I said, there's a thing where it's like mal means bad. And they just keep going here, and they address things here that they point out that even if we had any doubts, the Supreme Court made announcements at O'Shea, Imbler, and Dennis. And he says, I am unconvinced these cases establish settled law and judicial immunity from prosecutions. And I agree. But they keep going here because we're still going to get into the deprivation of rights argument. And they point out here that she's making two underlying premises with her arguments. That judicial immunity is established in American common law, and two, that deprivation of rights under 242 is an exception to that rule. And they, as he says, the common law judicial immunity in criminal case rests on Floyd, and Floyd has only been cited by the Supreme Court in civil cases. Thus, there is weak evidence for the existence of a common law judicial immunity from criminal prosecution for official judicial acts. And they say, moreover, arguing the lack of immunity establishes judges are immune from criminal prosecution under every other criminal statute, overlooks the specific historical context in which Section 242 was passed. And he says, as the government argues, must Congress comb through every federal criminal statute to indicate which statutes apply to judges and which do not? And he says, I'm unconvinced the absence of immunity establishes judges are immune, which I think is a great argument. Once again, chat, this woman is now crashing and burning. And, once again, Dugan asserts there's only 3 categories of cases which judges aren't immune. And once again, it's for their wholly unofficial acts. Second, a judge can be prosecuted for the criminal deprivation of an unconstitutional right under 242. And the judge can also be prosecuted if they conduct an official act, but the act is coupled with an ordinary crime for the pursuit of enrichment or gratification. And it says the first category doesn't merit discussion. The parties agree judges are not immune from unofficial acts. And this is where they cite a state court judge of California who's recently convicted of murdering his wife. Well, they watch television. Everybody agrees. And nobody believes that judge could evoke immunity. And everybody agrees with that. The second one is discussed in depth above, but she's not charged under that and agrees judges are not immune from prosecution under 242. And the third class is where judges, and this is where judges are prosecuted for actions related to their duties, but are coupled with self-serving criminal activity like bribes or kickbacks. And that warrants more discussion. And she argues these cases are distinguishable from other crimes because of the self-serving nature. And she contends she was acting selflessly with no hint of self-dealing, which is interesting. She's like, I was helping him. I was trying to help this poor man escape, this Laheckin immigrant Reno. I let him run away. You're like, okay. They say, but whether a judge seeks his own self-gratification or self-enrichment is not the distinguishing feature for immunity. What matters is whether the judge, even in performing her official duties, is accused of committing a crime. Take, for example, and this is a great one, the Kids for Cash scheme in Pennsylvania, where 2 juvenile judges accepted kickbacks for sending juveniles to particular private prisons. The judges alleged to have used their influence as judicial officers to select these childcare detention facilities and filled those facilities with juveniles to earn kickbacks from the jail managers. And these 2 judges got like $2.6 million for their stuff. Yeah. Yeah. Self-gratification, meaning for their benefit. And CV1129 says, isn't that essentially a confession? Oh, here's the thing, guys. She 100% says, yes, I did it, but fuck you. I'm a judge. I'm protected because I'm doing judge stuff. And she's arguing I was acting selflessly because she's misconstruing what self-gratification means. For her, like, bless you. 2.0 had a sneeze. He had a sniffles. But how does it work here? And it's like, honey, you're completely off target here. You're completely off target. Backdoor Dugan, yeah. Breaking the law isn't judge stuff. Oh. Revan said she's going to be the real version of Orange is the New Black. Yes. Bush is right, pulling an Ethan Ralph. I think it is you who is misconstruing what self-gratification means. Yes. And real quick, guys, we got to catch up on some things here. Dolly talks with 3 more subs. Let's freaking go tonight, chat. Let's go tonight. Johan says, I'm going to watch a live stream of that land, bish. God bless the goal. Yes. And then Cool Boy 52 for $1.99 says, I'm just a real cool boy. Well, thank you for being here. Thank you for being here. Z-Star says, the history of lobotomies is wild. It was a careful medical procedure in Europe, and it was imported to the U.S. They said, yeah. And really, that's what they do in America. They take a metal rod and they shove it up in there and they swirl it around. In Europe, it's a little more precise. Yes. Jefferson Post says, the Kennedys are pro-women. Yes, they get lobotomies and Buicks. Little Mary Jo Kopechne joke. Oof. Bad Weather Biker for $12. Interesting number. Thank you. Says, so glad this channel still talks about the law. Keep up the good work. Well, thank you. Thank you. I try. You're my 3rd favorite YouTuber behind May and Othias. Well, don't they technically count as 1 since they're on C and Arsenal? But I'll take 3rd or 2nd. I mean, whatever, however you wish to count it. I'll still accept it. Thank you, Bad Weather. It's good to see you, man. Hope you're doing well out there. Hope you're doing well. And Mystery Sniper for $3. So again, we're just doing like weird amounts right now. Tell Angela to unblock me. Stuffa. You can unblock whoever you want. This, you are allowed to do as you wish here. Block whoever you want. Mystery Sniper, Suffa. Yes, is this a law channel? Yes. Yes, it's always been a law channel. But anyways, these judges were alleged to have done, amongst other things, remove funding from the budgets from their juvenile detention facilities, sign a placement guarantee agreement, and grant an injunction when presented the results of an audit of the facility from being disclosed to the public. The judge was alleged to have sentenced thousands of juveniles in violation of their rights. And that was the thing. Like, if you did something stupid, it was like, you're going to juvenile detention. And they weren't supposed to go. The judges pressured probation officers to make recommendations in favor of incarcerating kids, concealed their proceeds, and failed to disclose their relationships with the other defendants. They were civilly sued under 1983 for their actions, and the court found the judges to have absolute immunity for conduct pursuant to their role as officers. And this is a problem. The court determined the immunity applies if the judge has jurisdiction over the dispute and conducted an act. And the plaintiffs argued, though, they were made corruptly. And the court disagreed, though, stating the allegations they had a corrupt motive was no different than the allegations for the judge in Dennis, where the Supreme Court found judicial immunity. And they said that imposing delinquency sentences were judicial acts. And the fact they were made corruptly was irrelevant. They said, however, to the extent the actions the judges were not in nature, such as the signing of an agreement, budget request, judicial immunity didn't shield their conduct. And because of this, one of the judges escaped civil liability for the vast majority of his conduct. But the judges were still subject to criminal prosecution. And one of them was just pardoned recently. And they note the judges were indicted by a federal grand jury. And the judges were indicted under federal racketeering laws. And they say, while judges may be civilly immune, it does not follow they're also criminally immune for their holy judicial acts. And they say, while judicial immunity shields you from criminal liability, it doesn't protect you from criminal prosecutions. Now, Dugan's getting desperate. She's in trouble now. She's in trouble. Wait, hold on here. What? James Reed says Carmelo Anthony's on the run? No, he's not. Why did he go on the run? Hold on here. Is this a real thing? Let's see here. Yeah, he's set for June of next year. Yeah, I don't think anything he's saying is on the run right now. So I don't see anything there, chat. Sorry. So, yeah, I don't see that. Let me see here. Let me see. Nope. I just double checked. I do not see it. Nope, don't see it. Might be late. Yeah. Well, he's going to be right in time for midterms. It'll be right in time for writing in the summer. So. But that would have been trippy if he ran away. Anyways, Dugan tries to cite the United States v. Claiborne. And regarding whether a judge who is truly conducting acts in the context of criminal immunity. In Claiborne, a federal judge was indicted for soliciting and receiving $30,000 from a Nevada brothel owner. Russell Greer, here's your path to glory, buddy. Here's your path to glory. In return for being influenced in the performance of official acts, specifically decisions regarding motions in their case. The judge was further accused of accepting money from the same individual in return for promising to secure the reversal of his criminal tax evasion conviction by bribing one or more of the judges of the Ninth Circuit Court of Appeals. And here they said the Constitution does not immunize a sitting judge from the process of criminal law, and that's true. And they say that this argument that you have to judicial independence is bullshit. And they said that judges enjoy the same protections as ordinary citizens from vindictive prosecution, and that criminal prosecution encounters several procedural barriers, such as the indictment, burden of proof, and presumption of innocence. And they said that criminal conduct is not part of the necessary functions performed by public officials. And that's true. There is no duty to take a bribe. And punishment would not interfere with the government. And they says, rather, it can be scarcely doubted the citizenry would lose respect and confidence in a government where judges are held to be above the process of criminal law. And that's true. And they say, though, despite the conducting judicial acts of handling motions sold in his office, they say, well, true, this fact does not make it a close call. And they say, rather, Claiborne reiterates the principle that even when performing clearly judicial acts, a judge is not immune from criminal prosecution for committing crimes while conducting the act. And they say, well, many of these cases involve crimes where the judge's motive is financial gain. It doesn't follow that there's no authority for the proposition that that is limited. And now we get to the big one here, where she tries to rely on Trump v. United States. The magistrate's going to be like, we ain't doing this. We ain't doing this. He's like, honey, it don't work. So she finally cites Trump v. United States, where the Supreme Court found the president had absolute immunity for criminal prosecution for conduct, what is an exclusive sphere of constitutional authority. And it says, while acknowledging that Trump was addressing immunity in the context of the president, Dugan argues that Congress indirectly addresses judicial immunity because, in her view, Trump's pronouncement of presidential immunity is grounded in the proposition that judges have absolute immunity in criminal cases for judicial acts. And the magistrate goes on. Cecilia, wasn't that? Well, we're going to get to this. Don't worry. The magistrate is pointing out her argument. Now he says, in Trump, like here, the parties did not dispute that criminal immunity does not apply to unofficial acts. They say, as to official acts, however, in arguing the president is absolutely immune from criminal prosecution for acts within the outer perimeter of his responsibilities, Trump looked to Nixon versus Fitzgerald, a civil case in which the court concluded that in view of the special nature of the president's constitutional office and functions, we think it appropriate to recognize absolute presidential immunity from damages liability for acts within the outer perimeter of his official responsibility. And they say that Trump argued that given the pronouncement of Fitzgerald for acts on the outer perimeter, he must be absolutely immune for criminal prosecution as well. And the court agreed. And they said the nature of presidential power requires a former president have some immunity for criminal prosecution with respect to the exercise of his core constitutional powers. And they say the immunity must be absolute. And they say, as the non-core functions falling within the outer perimeter, the court concluded the president has a presumptive immunity from prosecution. And the government can overcome it by showing and applying a criminal prohibition to the act would pose no dangers of intrusion on the authority of the executive branch. And they said, though, the court reiterated the president is not above the law. They said, though, the president charged with enforcing federal laws is not above him. However, they also found it had to balance two competing interests: the president's ability to execute the duties of his office fearlessly and fairly, and the fact federal criminal law seeks to redress a wrong to the public as a whole. They say, in finding this balance, the court concluded the separation of powers necessitate the president having absolute immunity for core constitutional powers and at least a presumptive immunity for all official acts. And now she's saying, well, because you relied on Fitzgerald, it's rooted in cases applying absolute immunity. It follows that the Trump case clarified the president is entitled to the same immunity for prosecution that judges have long held. And yeah, that's not true. That's not. I mean, I'll give her credit. It's a good argument, but like, it's bad. It's not going to work. It's not going to work here. And they say, while she asserts Trump simply extended the same immunity, this argument takes the leap too far. Trump says nothing about criminal immunity for judicial acts. And if Fitzgerald, while the Supreme Court looked to the jurisprudence regarding immunity, the court was clear the grant of absolute immunity for civil damages for outer perimeter acts of the president was due to the special nature of the president's constitutional office. And they noted the president occupies a unique position in the scheme as the only person alone who composes a branch of government. True. It says, even so, criminal immunity exists only for a president's core constitutional powers, meaning those articulated in the Constitution, such as the power to pardon and the power to veto. It is in those limited cases that a president's motive cannot be considered. They say even if the president can take a bribe to grant a pardon, because a pardon is a core power, it would violate the separation of powers of question. And they say, however, for the non-core powers, the Supreme Court did not grant the president blanket immunity. Instead, they're only presumptively immune, and the immunity can be overcome by showing that a criminal law posed no dangers of intruding on the separation of powers. And they say perhaps in the future, the court will expand judicial immunity. It has so firmly established to the criminal prosecution of judges, as Dugan urges. He said, this time, I'm unconvinced that either the common law or the Trump decision provide the authority for applying that framework to criminal acts. So he's saying, suffer, bitch, we ain't doing it. All judges think this, though. Oh, all judges think they're 100% immune all the time. Guys, and this is where I would tell you, John Bryan, the civil rights lawyer, he addresses this issue with the divorce judge who shows up, and they take everybody over to the guy's house, and she demands to go inventory stuff in his house personally, and she threatens to arrest the husband in the case. That judge thought she was 100% immune, and wow, did that bitch find out she was wrong. So that is what happened there. And they say, just real quick, they're going to get to the summary of the existing laws here. And they say, look, having reviewed this, the applicable law can be summarized as follows. In the civil context, it's well established undisputed judges have absolute immunity from civil lawsuits. While it's not clear what constitutes an act, the Supreme Court counsels courts to consider whether the act is a function normally performed by a judge, and whether the parties dealt with the judge in their judicial capacity. And they said, in civil immunity, that immunity is not overcome by allegations of bad faith or malice. Yep. Now, in the criminal context, though, he's distinguishing it. The case law supports the following. First, judges are not immune from acts wholly outside their roles as judges. Dugan cites several examples, such as the judge who was convicted of murdering his wife, and a state court judge who was convicted of sexual battery of a female lawyer in his chambers. He says, second, judges are not immune from prosecution for the criminal deprivation of constitutional rights. This one doesn't matter because that's not on the table. And he says, third, judges are not shielded by immunity from prosecution for acts, though related to their duties, that are in violation of criminal law. And they say, applying these principles above, does the immunity shield Dugan from prosecution because the indictment alleges she violated federal law while performing her duties? The answer is no. Oh! Ow! Bum, 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 bumpa. Yo, she just took total judicial death. TJD, chat. As discussed above, there's no firmly established absolute judicial immunity barring prosecution for acts of judges. Other than 17th century England, the Supreme Court has only applied the concept of immunity for civil acts. And they said, even before the lower courts, with the exception of malfeasance, the cases cite in support of her argument arise in the civil context. Meaning that's all she's got, civil cases. And they point out where judges have been prosecuted for conduct performed in their roles also answers this question in the negative. They talk about the kids for cash thing. They talk about judges being immune from civil suit. And they say, though, judges were however prosecuted criminally because even though the judges performed their duties, their otherwise conduct was criminal, didn't shield them from prosecution. And they say that, trying to argue that the charged acts are devoid of self-enrichment or gratification, saying that there's no leverage or bribe or kickback, or favor or to commit another crime. He says that distinction takes these cases out of the shield of immunity is not self-enrichment or the motive. It's whether the law has been violated. That's it. That's it, Judge. Did you break the law? I am the law. I am the law. That's what he just said. So in other words, a judge's actions, even when done under capacity, do not bar prosecution if you're done in violation of the criminal law. I'm law. I'm law. They say consider another case, though. And this is one here, guys. Judge Shelley Richmond Joseph. This was kind of a shitty one that happened, but she was a similar case. The only case with similar allegations, the United States versus Joseph, where she was a federal judge, and she was charged with obstruction of federal proceedings, where an ICE officer arrived at the courthouse to take into custody an immigrant who had been arrested days earlier, who was allegedly the subject of a detainer and a warrant based on that final order of removal. Homeland Security intended to detain him, and she allegedly facilitated his departure from the courthouse using the rear sally port of the courthouse on the courthouse's lower level rather than through the main door. And she tried to move to dismiss the indictment on judicial immunity grounds. And the district court declined to resolve the question, finding even if it did extend to the context, it would only apply where the acts were within her jurisdiction. In this case, the indictment alleged she was corruptly into such immunity to the extent it exists, does not shield corruption or bribery. And the court concluded that it was not within this court's province on a motion to dismiss to determine whether judicial immunity, even if it encompasses criminal liability, provides a viable shelter for her in the circumstances alleged. And they say the indictment here alleges that Dugan acted corruptly. They use the words that mean things. But as the Joseph court found, to the extent immunity exists, it does not shield against corruption. And he says, in my view, this is consistent with cases where the judges were prosecuted for performing acts. Now, so real quick, guys, you want to get to this, though. What happened to Judge Shelley? Well, things kind of worked out okay for her at the end of the day. What happened? Well, ultimately, imagine this, guys. This went all along. She appealed it to the, and ultimately it was in 2020. She got a motion to dismiss, and it got denied. She appealed to the First Circuit, and they heard oral arguments in December of 2021. Her case, the court denied her motion in 2020. Well, guess what happened in November 2021 and then into 2022? By September 2022, they dismissed the charges against her. So, there you go. The U.S. Attorney's Office in that place in Massachusetts went, no, we're not prosecuting. Yep, the Biden admin dropped the charges. So she's still there, guys. She is still, she's all right. She's all right. So, good, that's, yeah. So, yeah, she got BTFO'd, guys. I mean, that is what it is, chat. It is what it is. So, and they say, in my view, this is consistent where judges were prosecuted for performing official acts that were intertwined with bribery or extortion, even where judges were acting in their official role. When the judicial acts violate criminal law, immunity is not by prosecution. He does say, I agree with the judge in the amicus brief of the former judges that a judge plays many roles when sitting on the bench. She must not interpret and apply the law to the facts. She must also ensure efficient running of her courtroom. He says, thus, I agree that determining whether a warrant establishes probable cause, directing people outside her courtroom to talk to the chief judge about a planned arrest, addressing a case off the record, telling people in her courtroom what door to use and re-enter the public hallway, allowing the party to appear by Zoom are all a part of a judge's job. They are, to an extent. She says, I also agree with Dugan and former judges that appellate courts are the proper forum to address disagreements with a trial judge's opinions, errors, and mistakes. He says, however, I do not agree the case law supports these acts bar prosecution where the indictment alleges the acts were done corruptly or facilitate violations of the criminal law. Now, they point out that Joseph appealed the district court's denial on immunity grounds. The First Circuit dismissed the appeal, concluding it lacked jurisdiction to review the district court's dismissal based on her asserted common law defense of judicial immunity. They say, as Dugan does here, Joseph argued the immunity protected her against not just conviction, but against prosecution. The First Circuit disagreed, and they said that finding immunity, even assuming it applies, does not provide a right to not be tried that could serve as a basis for interlocutory review. The court ultimately concluded she cannot obtain review for immunity defense unless she could show that her claimed right not to be tried was explicitly grounded in a statute or the Constitution, which she cannot do so. Now, they go on to talk about at the bottom, the indictment does not charge Dugan for opining on the fly, managing a courtroom, or allowing someone to appear by Zoom. There are no and cannot be federal statutes criminalizing such conduct. Rather, the indictment says she violated federal laws by knowingly concealing EFR, a person whose arrest warrant and process have been issued under the provisions of the law of the United States so as to prevent the discovery and arrest of EFR after notice and knowledge of the fact that a warrant and process had been issued for the apprehension of EFR. And then 2, what are the other things she did? Well, she corruptly endeavored to influence, obstruct, and impede the due process of proper administration of the law under which a pending proceeding was being had before a department of the United States, namely the arrest of EFR for purposes of removal proceedings conducted by United States Department of Homeland Security. And he says this conclusion does not leave the judges acting in their capacities or judicial independence at the mercy of prosecutors. They talk about in Claiborne, the judges enjoy the same protections as ordinary citizens from vindictive prosecution. I agree. Just like us. One of us. One of us. One of us. And they point out that the prosecutors have to complete all the things there are for probable cause. And ultimately, the prosecutor must prove each element of the charge offense beyond a reasonable doubt. And they say, for these reasons, I recommend the motion to dismiss the indictment. Please let immunity be denied. Now, here's where they kind of blow through things. They talk about the 10th Amendment, which this lady's probably never believed in the 10th Amendment till now. And she claims that the prosecution under federal law overrides her ability to administer Wisconsin courts. And she says the Constitution is not a federal government to superintend the administration and case-by-case functioning of state courts. When they talk about a Joseph, they raise similar 10th Amendment challenges. And they argue they're being charged for their decision not to assist ICE. And for all kinds of things there. And the district court found that these are not true. They require the assessment of disputed facts and other evidentiary analysis. They say the same is true here. The indictment alleges Dugan violated the two statutes and cites a statutory language for both. Whether she violated these statutes the government accuses or whether she was merely performing her duties, these are the question for a jury that cannot be resolved on a motion to dismiss. And additionally, the allegations could also be addressed or are better addressed by the state's own judicial discipline procedures, does not, as a matter of law, require dismissal of the indictment. Even if you can get the judge tossed. Well, no, we're still having the case. You still have it there. So, no, it's not where we get amicus cream from, Boosh. Missouri battle flag. Hold on. Do I hear talking outside? Thought I heard talking. So, yes, they're not one of us. They're part of the club, and we're not invited, Sean. Plus, I don't think they have a chair big enough for you over there. Well, thank you, man. Hope you're doing well. He says, for these reasons, dismiss on the 10th Amendment ground should be denied. Constitutional avoidance. Her invocation of this canon is misplaced. And he explains constitutional avoidance is a canon of construction that comes into play when language of a statute is ambiguous. The canon is a tool for choosing between competing plausible interpretations of a statute. It counsels courts to first ascertain whether the construction of a statute is possible to allow avoidance of the constitutional question. The canon has no application, however, in the absence of ambiguity. And she tries to invoke the canon to argue the two statutes conflict with the Constitution because it be based on the 10th Amendment. And she argues the court can avoid the questions by deciding the case on immunity grounds rather than addressing the 10th Amendment issue. And the judge says, again, this is not how you do this. Dugan does not allege ambiguity in either statute that would require the court to consider a plausible interpretation. She is simply repackaging her 10th Amendment argument for which the reasons above cannot be resolved for a motion to dismiss. And he says, next she invokes the canon to argue the court could rightly construe these to avoid any constitutional concern. But she doesn't raise any concerns with either statute. And all she can say is the indictment fails to allege conduct that constitutes concealment. And this is not the constitutional frame. It's an issue to be resolved at trial. And remember, chat, we get to this when you're arguing about the facts. That's not here. That's not here. So they say further, she argues these indictments fail to allege a proceeding within the meaning. And they say, while she argues that such removal proceedings cannot, as a matter of law, constitute a proceeding for the statute, once again, she's not arguing the statute is ambiguous. So they say neither of these questions evoke the use of constitutional avoidance. And there's no questions about the ambiguity in the statutes. I see none to address. And then he goes on to one last spot. He's like, factual disputes not properly resolved. He says, in light of this, this counsels too much against dismissal. The court cannot resolve the disputed questions of fact on the motion to dismiss. And they said, for example, she argues that federal agents disrupted her courtroom to effect the arrest. Well, did they? While the government asserts at trial the agents did not disrupt any proceedings, well, that's a factual matter. We have to address that at trial. And they say Dugan affirmatively chose to pause an unrelated case, leave her courtroom, and interrupt a colleague's proceeding to get her assistance and then confront the agents. Dugan argues she had the right to make decisions involving her courtroom in cases, including directing individuals to use a certain door, conducting a case off the record, and opining off the cuff on a legal issue. And the federal agents improperly interfere with the right. The government says, though, she's relying on trying to run a courtroom, but intentionally misdirected the agents, and she did. And she disputes the government's versions of events. Well, there you go. That's a factual dispute. And the government will have the burden of dealing with this at trial. Yep, and that's how it works. Well, that's not how it happened. Oh, we have a factual dispute. We're moving forward to trial. So they talk about the amici arguments. There were two separate arguments made for the amicus curiae, friend of the court. It was filed by 138 former state and federal judges. La heckin' Judgerino's chat, the creamer read it. It supported the motion to dismiss. The second motion was filed by the Center for American Rights. This organization seek to file an amicus brief in support of denial of Dugan's motion to dismiss. Both motions are granted. I thank the amici for their time and their contribution to consideration of this thing by the case. And he says, generally because the amici are not parties, they cannot raise issues not advanced by the parties. So the amici are allowed to make, and this is rare, chat. Remember, district court case. So they were given permission by the magistrate. And the magistrate's telling the judge, look, let them make arguments for us. We might be able to pull good points out of it. And he says, though, thus I have disregarded any challenges contained by the amici that were not raised by either party. And he says it's well established that there's absolute immunity from civil lawsuits for monetary damages. He says this is not, however, a civil case. Yep. He says, accordingly, I recommend the motion to dismiss the indictment on immunity grounds be denied. And I dismiss it for the 10th Amendment case. And then finally, just under the merits here, it's going to be denied. And they say she's presumed innocent, and innocent she remains unless and until the government proves a case against her beyond a reasonable doubt. So there you go, guys. There you go. Good as made a Red Bull. Yes. Dugan makes everyone yawn. Yes. All right, chat. Hold on 1 second. I'll be right back. I got to grab one thing, and I'll be right back. Hold on. Be right back, chat. I'm grabbing my wiener. It'll take me a little longer than that. Give me some credit. So it's recommended. Remember, this is the magistrate recommended to the judge. It's recommended that she get the Ricada treatment denied. And that the motions to file amicus briefs be granted. And the motion for a supplemental jury questionnaire will be addressed by Judge Edelman. And they say here, pay attention to your local criminal rules and rules of civil procedure and general local rules. Written objections to any recommendations may be filed within 14 days of the date of the service's recommendation or order. Objections are to be filed in accordance with the Eastern District of Wisconsin's electronic case filing procedures. Failure to file a timely objection shall result in a waiver of a party's right to appeal to the judge. Because remember, this is done by the magistrate, so you can contest this and say to the judge, no, she got it wrong. She got it wrong. So, there you go, chat. Suffer Judge Dugan. Now, here's the thing. Will the judge accept this? Probably. You don't have the right to break the fucking law while you're the judge. You don't. And she shouldn't get that right. She should have to suffer. Remember, no one's above the law. No one's above the law. Okay, well, how about now you're not above the law? Well, this is different. Yes. Let's see your chat. All right, so even crap judges can make it SCOTUS. True. Is there a Russell Greer tonight? Am I wearing a bathrobe? No, I'm wearing a shirt. Jesus. Joe Loy says, I've cooked badger for many years. Oh, I've cooked for a badger. I was about to say, did you I was about to say, who the hell eats badger? Who the hell eats badger? Oh. Yes, SAPA judges, known as above the law. Yes, unless you're on the Epstein list. Judge Edelman is a crap judge, according to Dan O'Donnell and Mark Belling. Yeah, well, we're going to deal with what we got to deal with. Did I see the clip of Nick dumping Randazza on stream? No, but, that's the funny part is, real lawyers talking about real lawyer shit. And imagine that, your attorney's a big First Amendment guy, and you're like, shocked Pikachu face when he's for the fucking First Amendment and access to courts. Literally the antithesis of what you're arguing. Pikachu face, shocked Pikachu face. Imagine that. Imagine that. So, Revan JJ for 199. It's good to see you, man. Hope you're doing well. It's been a little while. Hope you're fine out there. Self-importance is fine for being gone too long. Yeah. Well, I'm glad. Yeah, good to see you, man. Good to see you. Nick Kreuzer for $14.88. Oh no. Chat, we can't deal with that here. We can't deal with that here. Let me tell you what. No. EDW after for $4.20 since we just donating random amounts. Thank you. Amateur Iconoclast donated $160. How did you do this? I've seen you guys do this before, and I remember back in the day when we had a couple of those all-night streams, and you guys would donate retarded amounts. I don't know how you donate that much. I didn't think you could. I thought you were stuck at $2. Unless you're donating super stickers or something, I guess. I don't know. Weird. DF88 says, state-sanctioned sterilization is part of the gay agenda. Changed my mind. Well, I don't know. I mean, some of that sterilization was going on back in the day when there weren't gays. So nowadays, yes, it is. Getting little boys to chop their peckers off and girls to cut their titties off. Yes. And then, yes, that's all now part of the agenda. Revan's saying, interesting off topic, but POTUS just ordered twice, actually, that the Epstein files released in full. I'll believe it when I see it. He's getting ratio and Untruth helped waking up. Yeah, well, I'll believe it when I see it. And hopefully he's actually going to do that, and it's just bullshitting us about Ukraine. I kind of get the feeling we're going to get bullshitted on Epstein and bullshitted on Ukraine. So, yeah, sadly, Chad, I kind of have that feeling. So, let's see here. Fix this. Ammo is currency for $5. Thank you. It's good to see you, man. Is saying that currently at Costco, we need to deport the Indians and Muslims and everybody with a Star Wars name. That would be a good fucking idea. That would be a great start. I remember there was somebody on Twitter today, and they had a sign, they had a poll up. It's like unchecked Mexican immigration or unchecked Indian immigration. And it was 1,000 votes, and it was 1,000 to nothing for the Mexicans. And it's like, oof, what happened, India? Nobody wants to redeem. What happened? SAR! And then EDW up for $169. Once again, leaving you speechless. Oh. Maddie for $6.90 says, suck it, Sean. Well, that's okay. I get how you can do that one. The foreigners love Costco. Yes. Did you know in India they literally consume cow excrement? No, not literally, but I know that they literally poo in the streets. Google gift card, SAR. That's how they do the remittances in Google Play cards, not Western Union money orders. Oh. We have camps of the people with Star Wars names. Well, there we go. He kicked Randazza off stream during the body cam. It's hilarious because you see him reach out and do it. Well, softball. Yes. They're making the frogs gay. Well, of course they are. Of course they're making the frogs gay. It's part of the globalist agenda. That's what the globalists do. Let's see here. There are 2 times more Indians with an IQ below 75 than there are Americans in total. Well, I wouldn't doubt that. Anything goes says they poo in the streets of California too. Yeah, well, it's already colonization of ideas. Matty B for $7.13 says this D won't suck itself. Well, is that what you say every day when you're at the truck stop? You're like, oh god, these dicks ain't sucking themselves. We should do a watch on locals of Codex Patch Eat 3. Oh. Could Randazza get in trouble with exports over his admitting casual drug use? I don't know. Maybe not really. Like, unless he's like, yeah, I just did it, then yeah. But if it's like a long time ago, no. Let's see. Is Russell Greer a Pajit? No. No, he's a goblin. Russell Greer is just a goblin, chat. So different. You also have poop maps in San Francisco. Yes, you guys do. Sun Seal is saying, I feel like the only person I can ask this of, Sean. All right. Either that's flattering or not flattering. I don't know. We're gonna find out here. Now that Jeffrey Epstein investigation has been concluded, how subject is the entire case to FOIA? I don't know. We're gonna see. We'll find out. I'm sure they're gonna make up reasons not to, though. At this point. I'm sure that they will figure out a way to say no. So, and why did people change the, hold on here. I need to fix something. Well, how did this change? I don't know how to fix this yet, so. All right. There we go. But no, I'd like to argue we would, but probably not. Dr. Evil style, yes. How about no? Coke Fairy says most lawyers have substance abuse issues, to be fair. Most lawyers don't. A lot of lawyers do. But most lawyers don't have substance abuse issues. But a significant number of them do have it. Percentage of lawyers with substance abuse. It's 21% of all lawyers, according to the Betty Ford Foundation and the ABA. That's a lot. You might not think that's a much, but it's a shitload. So that's a lot. So 21%, holy shit, yeah. And that's for people who consider themselves problem drinkers. And 1 in 5 Seans has a substance abuse issue, yes. Are they counting sugar? Yeah, no. They're counting cholesterol. Yes, that means 21 and 100. Some lawyers also have an FTA issue. Yes, some do. Despite being 21% of the population, yes, we're responsible for 50% of the DUIs. Oh. So in a class of 300, that's like 63. Yep. That's still a shitload. Yeah, alcohol is probably the most common. It is. Alcohol is the most common. It's the easiest thing to get. It's the most legal thing to get. So, but that doesn't mean just alcohol. That means all kinds of things. I mean, a lot of things happen. So, there's there's a lot of problems. There's a lot of problems. So it's bad. You gotta keep track of lawyers out there. That's why, like, sometimes if like things are getting a little tough for a lawyer here or there, judge is gonna be like, "Are you okay?" Like, judge or other attorneys be like, "Hey, man, are you okay? Like, is everything all right? Do you need some help?" I mean, I've been in chambers before with another attorney, and the judge is like, "Hey, man, hey, Steve, are you okay? Do you need help? What's going on? Is there anything we can do to help you?" Because that happens. That's how serious of an issue it is, chat. That's how serious of an issue it is. So, ah. Mm. What did Steve say? Steve was okay. He just had some family problems. His kid had cancer, and he hadn't told anybody about it. So, and it was really tearing him up. So, like, he was like really late, and stuff was just kind of falling apart, and he was messing up deadlines, and he hadn't talked about his kid. Like, he's like, my kid's got cancer. He's like, my kid's gonna die, and I can't do anything about it. He just found out about it, and it was like, he found out about it like 2 months ago, and his kid only had like 6 months to live. So, yeah, happened. Rough. Uh, Steve, who? Not gonna say. Blue's Clues, Steve. No, his kid passed away a while ago. So, way to bring down the party. Yeah. Well, it is what it is. But I have heard stories of attorneys coming and judges like, "What's wrong?" And they're like, "Judge, I'm hooked on this, or I'm an alcoholic, or I'm on pills." And judge is like, "All right, well, we're gonna call the lawyers assistance program. We're gonna get you in a treat like and they're like, "You're not leaving till we figure this out." And I've heard of judges like, "We're clearing the schedule for the courtroom till I get you fixed." Or like, "I'm gonna get you in contact people. You're not leaving the courthouse till I'm done." So that happens. So don't dentists have the worst substance abuse issues? I don't know, but they have a lot. They have a lot. They have a lot. No, it's not Steve. You guys are being assholes. No, and that's what guys quit being fucking dickheads about that, okay? No, don't guess. And you know what? Steve wasn't the guy's name. I used a different name. So there you go. Jesus Christ. Think about it. I'm in Ohio. How would I have ever been in a courtroom with Steve Gosney? Come on, chat. Come on. Like I said, Steve's not even his real name. So Bella says, "No, I thought you meant someone we know." No. I said I was in a courtroom with an attorney and we got to go in chambers, and judge is like, "Are you okay? What the hell's going on?" Jesus. Guys are like, everybody's got to chill out. Lone Star, no, I know some of you guys weren't trying to be assholes, but some of you guys were definitely being fucking assholes out there. I don't think you were, but some of the chat were trying to be. Yeah, some of you guys are being very melanated. It's like, stop it. Stop it. Billy Bob Steve Jawinski. There, I solved it. Yes. So Stace says, well, we're not technically bright. Yeah, well, there you go. Trenton says Ohio invades Florida all the time. It's the third most common state for invaders. Remember, chat, Florida man came from Ohio. Ohio man migrated to Florida, and that's why you have Florida man. You should thank us. No, not Stephen Bennell III. His kid's not even. Destiny didn't name his kid Steve. You guys are messing this up here. So you guys are just ridiculistic. So, all right, chat. We're gonna land the plane now. It's 10:30. We're gonna land this plane. And we're actually gonna take a look at this here coming up because it's like a nice little bitty model. I wonder how much of this there is actually to put together. So, we're gonna take a look. Such a sad story, though. Yeah, it was a sad story, but you know, it's been probably like 10 years now. Actually, you know, it's probably been like 2017, so it's only been like 7-8 years now. So yeah, just don't the fuel cutoff switch. Sir, Eric saying the kid part was real. Yes, the guy's kid got cancer. And the kid only had 6 months to live, and he was like 2 months into it, and the guy was losing his mind. Yes. Yes, the guy's kid had some really nasty cancer that nobody realized until it was way too fucking late. So. If you guys want to, you guys are talking about Hayden, Aussie Overlord. Guys, go look at Hayden's Twitter stuff. It's not proper for me to say what happened to Hayden, I feel like. Go check out his Twitter. Some fucked up shit happened to his family. So go on his Twitter, Aussie Overlord. You can find it out there. Some shit involving a wood chipper is what happened to his family. So you would lose your mind in that situation? Yeah, and the guy did, but he got through it. So. So. Yeah, or just have Hayden on explain to himself. Well, they're in a position where he's not ready for that. So, guys, just look at his damn Twitter. Use your eyes. Pretend you're not Ray Charles. Read, or if you have to be like Helen Keller, water, Helen, water. Have someone spell it in your hand for you if you can't read. So. Yeah. Just Google it. Just go to Hayden's Twitter. You'll find it out. So, how far back? The past week and a half. You don't have to go that far back. You'll see it right away. So, a braille screen would be hilarious. All right, chat. So we're gonna head over to the model show. Actually, hold on here. Can I set that up in a way? Yeah, it's all over his channel on Twitter, guys. Like, some of you guys are being goobers. You don't have to be goobers. Don't goober it up. All right, chat. So we're gonna schedule this for what time is it right now? 10:35 p.m. There we go. All right. So with that said, chat, I will see you guys over there, over on the model stream. And in the meantime, chat, I just want you guys to know we got some stuff planned for tomorrow. We will do a members only stream. We got some other stuff we're gonna work on. Thursday night, we got a Thursday night show. And Friday, we're working on some things, trying to work on some stuff here coming up. So just you guys hang tight. Trying to come up with some things. come up with some things. And why did I go to the wrong page here? We might have special guest President Trump on. No, we won't. We won't. Not that lucky. We're not that lucky. Oh. But we are, I need to switch you guys over, so. All right, chat. This didn't work here. But anyways, I'll see you guys over there, chat. Just remember until next time. Just because you did it, it's not mean you're guilty. Unless you're one of these federal judges. Or, well, you're not federal judge, but when you're Judge Dugan, you're pretty fucking guilty. Suffer. Suffer, Judge. Suffer, Judge Jackson. Suffer. So, good night, chat. I'll see you guys over on the Mile Show. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the